Good afternoon. We'll call the Election Contest Committee meeting to order. Clerk will call the roll, please. Thank you. If there are not objections, the chair moves approval of the minutes from the previous meeting. Thank you. Minutes are approved. Again, good afternoon, everyone. As I explained on Monday, today we will hear from the attorneys in this election contest. And good afternoon to all of you. When I spoke to both attorneys, I asked them how much time they would like to have for their arguments, and they both agreed to 30 minutes. This was not something that I demanded or anything of that type. That was what they agreed to. When I asked them how much time they would like to have for rebuttals, they requested 15 minutes. Again, all parties agreed to that. That is correct? Okay. That was their request, and that is what all parties have agreed to. The attorney for Kayla Cater, Ms. McCormley, will go first. The attorney for Michael Bergen, Mr. McDermott, will go second. The rebuttals will go in the same order. Visual aids submitted for review, and they were submitted for review. They have been approved, and they may be used. Following arguments and rebuttals by the attorneys, each committee member will be given 15 minutes to ask questions of the attorneys. Committee members may not interrupt the attorneys while they are presenting their arguments or their rebuttals, nor may the attorneys interrupt one another. That also has been agreed to. Committee members may also use visual aids if they so choose, as long as they were submitted by noon today, and I don't know of any. Do you have any visual aids you want to put up on the? Okay. Very good. Thank you. Again, all of these procedures have been agreed to by the attorneys and Representative Wolf, the ranking member. The order for committee questions will be myself, Representative Meyer, Representative Jacobson, Representative Winchell, and Representative Wolf. Representative Wolf, is that still satisfactory with you?
Yes,
okay.
It is.
Thank you. I've also agreed that 5 minutes may be given for committee members to ask follow-up questions that might come up after they've heard some of the other statements. This will take place after all committee members have completed their 15 minutes of questioning. These procedures and timelines will need to be adhered to in order to be fair to all sides. We actually have a timer down there who's going to hold up some signs to help you know if you're starting to run out of time, so that you're not surprised and all of a sudden your time is up if you want to make some final points, that sort of thing. I will say there will be no additional committee work this week, and the next steps will be determined, again, based upon the arguments that are heard today, as I stated on Monday. I would ask that the attorneys prepare for this committee a list of witnesses they would like to have testify and submit it for our consideration by 2 p.m. tomorrow. Is that enough time, or do you need more time? Is that satisfactory? Okay, thank you. And that'll be Thursday, January 17th, tomorrow by 2 p.m. Okay, this will expedite the process should the committee determine additional information is necessary after the great deal of information I'm sure we will hear and see today. I would remind everyone that the central question before us, as we discussed in the first committee meeting, is do we open and count the 29 ballots in question? And then obviously if that decision were to be made in the affirmative, then of course they would be recanvassed and recertified. At this time, if there are no questions, Ms. McCormley, you may present your argument, and you have 30 minutes, and good afternoon.
Good afternoon. My name is Shayla McCormley, and I am the attorney for contestant Kayla Cater. This contest of the Iowa House District 55 election comes down to 29 ballots in Wenatchee County. They were mailed on time, and they have not been counted. These 29 votes must be counted for 3 reasons. Just 9 votes separate the 2 candidates in an election where almost 14,000 votes were cast. Information from the barcodes on the ballot envelopes was confirmed that they were mailed the day or days before the election, as required by Iowa law, and it's undisputed that the barcodes were read and they properly complied with the mail time frame. Third, ballots just like these 29 from Wenatchee County were counted in Fayette County. Ballots without postmarks that arrived after Election Day, and no one confirmed that they were placed in the mail on time. They were just opened and counted. We're asking that every vote count. There's a 9-vote margin, 29 uncounted votes, and the different counting standards in the 3 counties in the district raises an equal protection issue. This is a nonpartisan issue. First, I want to acknowledge there were 33 ballots that were received by the Winneshiek County Auditor after Election Day. It's our understanding, based on a representation made by the Winneshiek County Auditor, that only 29 of them were placed in the federal mail system as required by Iowa law. But we'll presume, for this argument, there's 29 until evidence is presented. This is not a partisan issue because of those 29 ballots, there were Republican ballots, Democratic ballots, and no party voters. Ms. Cater's asking that all of those legally cast votes be opened and be counted. It's undisputed they were placed in the federal mail system timely prior to Election Day, and the voters' rights are the basis of this contest. House District 55 includes 3 counties, parts of each of the 3 counties, Winneshiek, Clayton, and Fayette. On election night, Mr. Bergen and Ms. Cater were separated by 7 votes out of almost 14,000. Under Iowa law, Election Day is not the end of receiving or counting ballots. Ballots are received by the county auditor as long as they're received prior to the conclusion of the canvass, which is usually the week following the election. If they're received timely and then can be verified they were placed in the federal mail system, then they should be counted, as all 29 of these ballots were. In Clayton County, there's no concerns. The ballots were treated correctly. The administration of law was correct. However, in Fayette, there are about 25 ballots that were received for the House District 55 election. 12 of those ballots had no postmark, and at that point, Director of Elections Don William confirmed that 29 of them were opened by the auditor, not verified, 12 of them in Fayette County were opened, thrown into the counting, and potentially could have been illegitimate votes. Auditor counted them anyways. She didn't read the wire code, she just counted them. Let me be clear that Ms. Cater is not arguing or advocating to disenfranchise anyone. It's the understanding that the Secretary of State now says it's just too late, too bad, and that's fine. There's nothing we can do to undo that, and we don't want anyone to be disenfranchised. We're asking, though, that all voters be treated fairly and in accordance with Iowa law. It is important to note, however, that as of election night, there was a difference of 7 votes. Opening those ballots in Fayette resulted in Mr. Bergen receiving 2 additional net votes. So now there's a difference of 9 votes between the 2 candidates. There's not been any concern or outrage about counting those votes. However, in Winneshiek, 33 ballots were received after Election Day. Auditor worked with the post office, scanned the ballots, was verified that 29 of them complied with Iowa law. The barcodes were scanned by the postal system, and it was determined that they were placed in the mail stream as they needed to be counted. That's undisputed. However, still the Iowa Secretary of State and the Winneshiek County Auditor are refusing to count those 29 ballots. And this is leading to a serious equal protection violation. Voting is a fundamental right. It's guaranteed by the U.S. Constitution and the Iowa Constitution. It gives citizens a voice in the government, our representative democracy. The voter and the government have a social contract where if the voter abides by the laws, follows the voting laws, then the government agrees to count those votes. These voters followed the law. But now the government is knowingly and intentionally disenfranchising these 29 voters. And that point at which we deny voters the right to have their validly cast ballots counted, we undermine our democracy. In May of 2016, the Iowa legislature worked to ensure that as many votes as possible could be counted, leading to this issue of the intelligent mail barcode. The legislature acknowledged that postmarks had become an issue, that often the United States Postal Service did not postmark ballots. They didn't need to. Sometimes they're too thick, they can't be run through the machine. Sometimes they're oversized, and they have a prepaid return postage, which means they don't need to cancel any stamps. That's a problem, leading to something like this, where we don't know when ballots were placed in the mail stream. However, the United States Postal Service has used barcodes for decades. Barcodes track when mail went into the mail system, where it's going, where it's coming from. There's a lot of information in those barcodes. The legislature acknowledged that and decided that they would expand Iowa code, not just from postmarks, but in the 4 places that postmarks are listed. They expanded it to include a postmark or this intelligent mail barcode. All mail, regardless of size, thickness, prepaid postage, has a barcode. Those barcodes contain information, and this legislature acknowledged that problem with the postmarks and changed the law. They amended Iowa code to make sure that as many ballots as we could be counted. It's now possible to verify when ballots were placed in the mail system if an issue like this arises. Specifically, in Iowa Code 5317, the 4 times the code was amended, it looks pretty similar. The wording is almost identical with maybe some tense changes. It always includes postmarked by an officially authorized postal service or bear an intelligent mail barcode traceable to a date of entry into the federal mail system, not later than the day before the election. This law did not change when the ballots had to be placed in the mail. It didn't change how long they could be received. They had to be received before the close of the canvass. All it did was open up the ability to allow more of these ballots that were placed in the mail closer to the election time to be counted, especially in rural areas where we're losing polling places. More people are voting by absentee. And in those same rural places, they don't have a postal hub. Just like in Winneshiek, all of the mail gets sent into Waterloo and then sorted and then goes back. A minimum of 2 days to deal with all of the mail and get the ballots that were placed in plenty of time to be counted into the mail system. However, rather than promoting an expansive right to vote, the Iowa Secretary of State and opponents of counting these validly cast ballots have sought to use an argument and an administrative code that was written by the Secretary of State, which then narrows down the wording the legislature used. Note, in the code, in the law passed by the legislature, there's no capitals, there's no registered trademark, there's nothing else that would indicate that we are discussing this tracing program offered by the United States Postal Service. However, immediately after that law passed on July 15th, 2016, the Iowa Secretary of State passed administrative code, the Intelligent Mail Barcode Tracing, addressing the program that if auditors wanted to, they could work with the post office to implement a system where they had that technology in their offices. Makes it a bit easier. There's some other advantages. They have to register. They have to work with the post office to get it all set up. But that's the tracing system. That's not defining what an intelligent mail barcode is. Nowhere in Iowa code is intelligent mail barcode defined. An administrative code cannot change the meaning or narrow the rights that this legislative body gave Iowa citizens. The Secretary of State can't take away those rights, nor can it redefine the voting laws. It can explain how to administer and enact them, but not change them. And looking at the code passed by the legislature, next to the administrative code, they are different. The tracing system is not mentioned at all in the Iowa code. And when a definition is not provided in the Iowa code, we have to look at plain meaning. Now, I know this is not a court of law, but we're still relying on how we interpret statutes as a state. And what we do is we take ordinary meanings from the dictionary. Someone reading what would it mean? Intelligent mail barcode. The post office puts barcodes on the mail. It has information in it. And the Winneshiek County Auditor was able to go to the post office and get the mailing dates. Another issue with the Secretary of State's argument, as well as opponents of the wider admissibility of these ballots and allowing them to be counted, is the fact that the Postal Service announced in November 30th, 2017, that the Postal Service was discontinuing the use, they were retiring the intelligent mail barcode tracing system. And by February of 2018, they were migrating to an informed visibility system with a new registered trademark for that phrase. If we go with the Secretary of State's argument and the opponents of counting these ballots, the entire change to the code in 16, as well as this administrative code, are all invalid because there is no intelligent mail barcode tracing system any longer. It has been discontinued. And as a state, we do not interpret our statutes based on what another body says. We don't use registered trademarks. We're not using somebody else's word. In the Iowa Code, this is not a confusing phrase. And the Winneshiek County Attorney was able to use the barcodes to get the information that he needed on these 33 ballots. How could we define the intelligent mail barcode with a new program named Informed Visibility? You can't, and it doesn't make sense. The plain meaning, as we would use for our statutory interpretation, is to use the words as they are commonly used and attribute a definition that is everyday. Technical terms by law must be defined in the code. An intelligent mail barcode is not defined. We need to look at Iowa Code, not at the post office rules, not at the Secretary of State's opinions, but at what this legislative body, who governs the state, actually passed in the law. Those barcodes told us when these 33 ballots were mailed. It's also important to look at the role of this committee. The right to contest an election is provided by the Constitution. This body is given the right to govern that process. The legislature has previously passed several code chapters, 57, 59, and 62, that all in part govern this process. Most importantly, it's important to note the party's rights in this proceeding. Specifically in Iowa Code 57.5, the parties to any contested election shall have the right in open session of the court or tribunal trying this contest, in the presence of the officer having them in custody, to have the ballots opened and all errors of the precinct election officials in counting or refusing to count ballots corrected by such court or tribunal. This is currently the tribunal. And Ms. Cater has a right to request that this body have the ballots brought down here by their custodian and opened. Her rights are secured by Iowa law and the Iowa Constitution. To ignore these rights violates her due process rights. She also has the right to call witnesses. But this contest is not just about her. It's not about Mr. Bergen, it's not about Ms. Cater. This is about 29 voters who have not had their votes counted, who followed the law by placing them in the federal mail system as they were supposed to. There's only a 9-vote difference in this race. Citizens who are similarly situated must be given equal protection under the law. In Fayette, all votes were counted. Ms. Cater has never requested that votes be counted that were not validly cast. She's just asking that the undisputed 29 votes that were validly placed in the mail in a timely manner be counted. These voters are also all feeling disenfranchised. Republican voter Nancy Bouquet was one of the 29. And she says, unfortunately, I'm one of the unlucky 29 voters whose ballot has been set aside due to lack of common sense. To my understanding, there is a barcode that was printed on the envelope, and the U.S. Postal Service has said the barcode proves the ballot was mailed on time. What is the issue? Democratic voter Laura Stake was another one of the 29. And she has an even harder time getting to the voting polls because a few years ago, her quote is, "A few years ago, we used to have a polling site right here in Franksville. Lack of funding closed it down, so now we have to go to Decorah. To get to the polling place is about 14 miles. With Lowell, who's her husband, being disabled, it has been easiest for us since we lost the polling place here in town for us to vote absentee. I was devastated when I got the phone call that our votes hadn't been counted since they weren't postmarked. I was rather upset. We mailed them on time. It's not my fault they didn't get a postmark." Another one of the 29 voters, a no-party voter, registered no party, Robert Wilson, said, "My rights are being trampled. I just want it to be fair. The process is supposed to be a fair one. This is America. This isn't some third world country where they burn ballots they don't want counted. The committee owes it to the people to count every vote. They can't just justify not counting the votes." The Winneshiek auditor verified those 29 ballots were mailed on time. Their voters have a right to have them counted. Every vote should count. Thank you.
Thank you very much. Ms. McDermott, you may present your argument. You have 30 minutes.
And if we might, Mr. Chairman, we need to just swap out for the monitor.
Timer, did you hear that? We'll start the timing once he's actually ready. Thank you.
You ready?
All right, you have 30 minutes.
Thank you. I'm Matt McDermott. I represent Michael Bergen in this matter. This election contest presents a threshold question to be decided at the outset. What do Iowa's election laws mean with respect to the term intelligent mail barcode? This is not a partisan issue. This is a straightforward application of the election laws in place. If the House determines that Iowa law does not permit the counting of ballots at issue, as previously determined by the Winneshiek County Auditor, the House need not proceed further with this contest. It is a dispositive issue for this committee. Under Iowa Code Section 53.17, Sub 2, absentee ballots that arrive after Election Day may be deemed timely submitted only if they meet one of two criteria. If the return envelope is clearly postmarked, showing a date at least one day before Election Day, or if the return envelope bears an intelligent mail barcode traceable to a date of entry into the federal mail system not later than one day before the election. This challenge concerns only the second of those two criteria. The Post Office uses different types of barcodes. Of the different types of barcodes relevant to this matter are, broadly speaking, two types. Barcodes sprayed on envelopes by the post office after a letter has been placed in the mail for processing of the mail to its destination, and distinctly, barcodes placed on envelopes by mailers, enabling the mailer to track individual pieces of mail. Information that's publicly available on the Post Office's website describes the different types and uses for the different types of barcodes on mail pieces. And Angie, if you could bring up Exhibit 2. This document is printed from the Post Office's website. It describes the intelligent mail barcode. The intelligent mail barcode, it notes, formerly referred to as the 4-state customer barcode, was the new Postal Service barcode used to sort and track letters and flats. The Post Office routinely changes its nomenclature. The Post Office changed the 4-state customer barcode to the name Intelligent Mail Barcode. Now, if you go below that, it says, how does it work? Well, the Intelligent Mail Barcode combines the data that existed from two different previous types of barcodes. Look at the note below it. It says, note, the Postal Service Flat Mail Identification Code Sort, or FICS program, uses another type of 4-state barcode that looks similar to the Intelligent Mail Barcode, but it is applied as an ID tag on non-barcoded flat mail pieces only. So a barcode is not a barcode is not a barcode. If you'd go to Exhibit 4, Angie. This is the Intelligent Mail Barcode Tracing User Guide, again printed by the U.S. Post Office. This describes what IMB tracing technology is. On page 4, in the description, it says IMB tracing allows mailers, again, mailers, in this case, the auditors who are mailing these envelopes, to uniquely identify and receive mail processing data for outgoing mail and incoming reply mail pieces. That's what we're talking about here, the incoming pieces. Data includes the date, time, location, and sort operation of a mail piece processed at a Postal Service facility. It goes on to state, a mailer's proper application of these barcodes allows the Postal Service to generate IMB tracing scan data and distribute this data to the mailer. If you turn to the next page, it describes how IMB tracing works. In the second paragraph at the top, it says, prior to using IMB tracing, the mailer, again, the mailer, in this case the auditor, must become an IMB tracing subscriber. Upon establishing an IMB tracing account, mailers follow the IMB tracing process as noted below. And as noted below, in the next section, mail planning and preparation, the mailer decides whether to use destination IMB tracing, origin IMB tracing, which is what we're talking about here, or both. The mailer determines the information to be included with the Intelligent Mail Barcode. And this includes the service type ID and other features. If you turn to page 9, Angie, this talks about subscribing to intelligent mail barcode tracing. And in the top paragraph, it says intelligent mail barcode tracing is a free subscription-based service. Before being able to receive IMB tracing scan data, the mailer must become an IMB tracing subscriber. To become a subscriber, the mailer must submit a completed application form and verification of the mailer and/or printing vendor's ability to generate accurate and scan-ready barcodes prior to mailing. The barcodes with IMB tracing are put on by the mailer. And if you go down to the rest of the section there about the application for it, you see that there are a number of steps that must be undertaken in order to be part of this program. If you'd go to page 20, please, Angie. Once set up and in use, the mailer can receive information about, for example, incoming mail containing the mailer's intelligent mail barcoded pieces. Intelligent mail barcode tracing scan data is created each time a mail piece with the tracing service type ID is sorted on post office equipment. There are two ways that you receive the data about your mail pieces as they move through the system, either from a FTP upload or through downloading from an intelligent mail barcode tracing website. So two ways to get the information, and it's available in real time. They send it to you, or you go to the website and download it yourself. The post office's own processing barcode serves a different purpose. And if you'd go to Exhibit 5, Angie. This is again a printout from the post office's website. It describes how a letter travels through the mail process, through the post office system. It states under scanning and lifting images, every letter gets identified by a code consisting of a series of fluorescent bars imprinted on the back. In the next section, applying a barcode and sorting, linked with the identification code, a barcode is sprayed on the front of the letter. These are barcodes that are put on letters that don't already have intelligent mail barcode tracing. It represents the specific delivery address and consists of tall and short bars used for further sorting. The barcode sends the letter into a bin on the machine for a particular range of zip codes which identify the next processing point. Because this sprayed-on barcode on pieces of mail by the U.S. Post Office is not a unique barcode put on by the subscriber to intelligent mail barcode tracing, there is no readily available method for anyone to determine in a real-time or other rational way how to learn when a mail piece was put into the mail system. This feature is, however, expressly provided in intelligent mail barcode tracing. Now, the legislature put in place the change to Section 5317 sub 2 through passage of House File 2273. And if we could go to Exhibit 6, page 6. In Section 15 of this bill that put into place for the first time the words intelligent mail barcode, it requires the State Commissioner of Elections to prepare a report related to the use of intelligent mail barcodes by county commissioners of elections during the 2016 general election. The report shall include information on the number of county commissioners of elections utilizing intelligent mail barcodes on absentee ballot return envelopes. And then it goes on to state that the Secretary of State must deliver this report to the General Assembly. So this is not mandatory for county auditors to use this system, to use this process. As we looked at earlier, there's an application process that goes along with it. Section 16 of House File 2273 states that the Secretary of State may adopt emergency rules under Section 17A.4 and 17A.5 to implement the provisions of this Act. And those rules shall be effective immediately upon filing. So the Secretary of State in House File 2273 was expressly provided rulemaking authority on this legislation. If you'd go to Exhibit 7, Angie, page 9. This is the report that the Secretary of State filed for the 2016 general election cycle. The participating counties were Benton, Cerro Gordo, Clinton, Dubuque, Jones, and Woodbury. So 6 counties in 2016 used the IMB tracing technology to track the return of absentee ballots. 93 counties did not use it. You'd go to Exhibit 8, Angie. And at the bottom, this is a press release from the Secretary of State providing the 2018 general election results having been certified. And in the last sentence, it says, Winneshiek County is not one of the counties that has implemented intelligent mail barcode tracing. So we still have 6 counties doing it. If there's a question in anyone's mind about what was intended by reference in Section 5317 sub 2 on the meaning of intelligent mail barcoding, the administrative code provision, Chapter 721, Section 21.14 makes it clear what was being referred to. And if you could bring that up, Angie. This is the admin code provision, and if you could go even higher up than that, the initial paragraph. It says that a commissioner, in other words, an auditor, may choose to use intelligent mail barcode tracing to determine when an absentee ballot is entered into the federal mail system as an alternative to a traditional postmark verification. And it goes on in the next section. Prior to a commissioner's implementation of IMB tracing for an election, notice must be sent to the state commissioner. And that's where we have our 6 counties that do it. The next section, B, a commissioner may not implement or discontinue the use of IMB tracing while an election is open once absentee ballots have been mailed pursuant to Iowa Code Section 53.8. So you can't start it or stop it while an election is in process. Under the next section, 2114 sub 2, Part A. If you could just highlight A, Angie. If the postmark or IMB tracing information indicates that an absentee ballot was received by the deadline specified in Iowa Code Chapter 53, the ballot shall be included for canvass by the absentee and special voters precinct board. But under subsection E, the information provided by the commissioner to the board must contain the numeric value assigned to the intelligent mail barcode and a full report from the United States Postal Service. We have to have a way to verify with the post office what these results are. The only way that you get that report is through intelligent mail barcode tracing. You do not get it through use of the barcode that is sprayed on by the post office. And then it goes on to say in section F, a board member from each political party for partisan elections or 2 members from the board for nonpartisan elections shall review the IMB tracing information provided by the commissioner and shall certify the information by initialing the envelope and report. Again, we need verification that the information that we're using about when a mail piece was put into the system is accurate and valid. And so we have in place through the admin code here a process of doing that. There is no process in place whatsoever for doing this based upon a barcode applied by the U.S. Post Office that is not unique and not part of the intelligent mail barcode tracing process. Let's look at 2 envelope one from Winneshiek County. In fact, one of the ballots that we're talking about here, and one from Cerro Gordo County. Angie, if you'd pull up the information on Cerro Gordo first. You see there we have an address that is where the ballot is supposed to be returned to, and then you have the intelligent mail barcode applied by the Cerro Gordo County auditor, and it is this code that is used for intelligent mail barcode tracing. Now look at the other return envelope. There's no such barcode. At least there's no intelligent mail barcode tracing that's put on there by the Winneshiek County auditor. Now look below it. Go broader with it, Angie. There you see another barcode. That is the barcode that is sprayed on by the U.S. Post Office for purposes of processing. It is not sprayed on for purposes of permitting mailers to determine when mail pieces were put into the mail system. There is no way for the county auditor to readily determine when that mail piece was put in the mail without going to the post office. As shown in Exhibit 13, an affidavit from County Auditor Ben Steins, when he first went to the post office seeking the information about when that ballot was put in, the post office essentially said, I don't know if I can give this info to you. If it was intelligent mail barcode tracing, it would have been available in real time simply by downloading the information from a website. And it could be verified in all the ways referenced in the admin code. Using intelligent mail barcode tracing, we know that the information is A, readily available to county auditors, B, is readily verifiable, and C, there will be no delay in getting it. We know none of those things if we define intelligent mail barcode as the challenger requests here. So back to the question before this committee. What is the definition? What is the meaning of intelligent mail barcode? The legislature is fully equipped to decide what its own statutes mean. In this proceeding, you get to determine the definition of phrases used in your own laws. It's your job. The rules, though, of statutory construction all support the same interpretation. Iowa Code Section 4.1, subsection 38 says that technical words with particular meanings shall be construed according to such meaning. We don't give general meaning to technical words. Intelligent mail barcode is a technical term. It is not a term in section 53.17 that refers to any and all barcodes. Again, the admin code makes clear the intention. In section 16 of House File 2273, the legislature expressly gave the Secretary of State the right to enact rules to enforce its provisions. When an agency is clearly vested with discretion to interpret a statute, the agency's interpretation is entitled substantial deference by those tasked with interpreting it. One can also look to the legislative history. Senator Danielson was the floor manager of this bill in the Senate and spoke concerning the intention of this bill. Angie, if you could play a clip of...
Stuck, so that's why you're not seeing the amendment show up on the board. The chair calls up Amendment 5128. Senator Danielson, you are in order.
Thank you, Madam President. 5128 solves a persistent problem that we've had for a number of years. Iowa's current law, as it relates to absentee ballots, relies on the post office procedure called postmarking. Our law says that a ballot is not valid if it has not been received on Monday night of an election week with a valid postmark. The problem is the Postal Service cannot guarantee every ballot will be postmarked because of their internal technology procedures. So we've had a couple of years here where we've tried to solve it by switching the dates, by looking at other procedures for counting those ballots. The sum total is some ballots who have been received by the post office according to our law's deadline don't end up being counted, and through no fault of the voter, those votes are not counted. And we think that's wrong, and we tried to solve it. This year we have a technology called barcode. I'm going to use generally barcode technology, but it's the IMB tracing system. It's a service offered by the post office. This amendment says that the postmark procedure is still there and available, but if an individual auditor would like to purchase this service from the postal office, barcodes will be provided. They will be put on the return envelope for every absentee ballot, and the Postal Service can then guarantee near certainty for the date and time it passed through their system. If that's before midnight of Monday night, that vote is valid and can be counted, and we've solved the cases where the postmark is not there, even though it was in time. So we will count more votes. We will enfranchise more Iowa voters because their efforts will show up. Now, you should know this has been a bipartisan agreement. We worked with the House, Secretary of State's office. We think it's an elegant solution, but we also don't think it's time to mandate it at this time. So the language says it's an option for auditors in this calendar year, primary and general elections that are coming up. And then the Secretary of State will give us a report in January that says, here's the counties that used it, and here's the data to track those ballots, and hopefully will show that we have actually counted more votes because of it. That is the amendment, Madam President. There's also effective upon enactment language. Some auditors would like to do this in the primary, so that gets them the opportunity, and then emergency rules so that anything that needs to be solved after we pass the bill and the governor signs it can be done for the primary elections. I'd be happy to answer your questions.
Senators, is there further discussion on Amendment 5128?
The senator described in detail the intelligent mail barcode tracing system. He used those words. That was the intention from the outset. The law is clear that the state has a legitimate interest in protecting the integrity of its voting systems and ensuring the orderly and timely conduct of elections. Every single indicia of what the phrase intelligent mail barcode refers to makes clear it does not refer to the barcode that the challenger is requesting to use here. It would be completely unfair to change the meaning of that phrase and apply it differently here in a way that 93 other counties did not do. Winneshiek County did not notify the Secretary of State that it would be utilizing IMB tracing for the November 2018 election as required under Iowa law. Again, the rules must be set before the election. There are a number of requirements placed on voters seeking to cast absentee ballots that must be followed. If the voter forgets to sign the ballot envelope as required, the ballot is not counted. If the voter doesn't seal the envelope as required, the ballot is not counted. And if the voter does not ensure that the ballot arrives timely, it is not counted. It is the duty of the voter to ensure the absentee ballot timely arrives at the auditor's office. The integrity of our elections requires that we establish the rules by which ballots will be counted and that we stick to those rules throughout the entire process. Winneshiek County is not set up for and does not use intelligent mail barcoding to trace the date that a ballot is sent. The late received ballots without postmarks were lawfully rejected by the Special Voters Precinct Board. On the threshold question and the challenger's complaint before this committee on whether Iowa law permits counting of the ballots at issue, the answer is clearly no. Thank you.
Thank you. Ms. McCormick, you have 15 minutes for rebuttal.
Most importantly, we just heard about tracing. Tracing is not the issue. You have postmarks of a different variety. Some have dates, some have locations. Different postmarks are used by the post office. Different barcodes are used. We're not discussing the tracing system. Iowa code does not refer to the tracing system. Is it easier? Sounds like it. Can the auditors use to if they follow the rules? The Winneshiek County Auditor didn't ask to use the tracing system. We're not here discussing the tracing system. By the way, it's also a discontinued program. So now I would say the Secretary of State's administrative rule has a whole other host of problems. But tracing is different. We are not looking at what the Secretary of State said and what administrative rules he passed. We're looking at votes. We're looking at ballots that had barcodes on them. And no matter how many times opponents of counting these votes say that the Winneshiek County Auditor couldn't or didn't, or how do we get the information from the barcode? Well, the auditor did. And he verified in a statement to the Polk County District Court that 29 of those votes were placed in the mail system as they should have been. No matter how many times we cast doubt on the auditor not using the specific tracing system, he did, and it worked. And we're able to enfranchise another 29 voters. Why are we not counting votes? This program is discontinued. So now we're missing a definition. Council just said near the beginning that the Postal Service routinely changes their nomenclature. Then why on earth would our legislature base their laws on someone and an entity that routinely changes their nomenclature? There is no certainty in that. And if we continue to rely on them to define our laws, it will be an ever-moving target that does not make sense. We can't rely on the United States Postal Service to define our laws. The Wenatchee County Auditor had no problem. Him and/or his staff went to the post office and got the information from the barcodes. To say otherwise is to call him untruthful in his statement to the court. And to say that the other barcodes don't include that information also is untruthful. We know that 29 voters cast their ballots as they should have. And talk about what's not fair is to not count those votes. These voters signed their ballots, no problem with that. They sealed their ballots, no problem with that. And to say that they are required to make sure they arrive timely, they were there before Iowa code requires. Iowa code is clear. The ballots must be received before the canvass is concluded. And the canvass is required to even go to the post office to say, hey, do you have any more ballots before we conclude? That was all done. There were 33 ballots. We got the information off of them. 29 were validly cast. Why are we changing the rules now when it matters in this election? We're relying on outdated postal regulations, and we're relying on the Secretary of State's administrative rule about the tracing program. Sounds like a good program, and maybe the auditor should be required to use it, but they weren't required to use it, and that's not what is in the code. So going over all the different definitions of tracing and the requirements of the auditors, that's not what we're talking about. That is a secondary, different issue. The tracing program is a way the auditors can implement using the Intelligent Mail barcodes. The Secretary of State had the authority to define how this process works, and he did. But it's the tracing process, not defining what an Intelligent Mail barcode is. Again, counsel said that this is a technical term. Every time a law includes a technical term, it is clear it must be defined. Nowhere in Iowa code is Iowa mail barcode, is Intelligent Mail barcode defined. So we use its plain meaning. And once again, no matter how much doubt there is, the Wenatchee County Auditor did that and used the barcodes, got the information. The integrity of the elections require that we count votes, not that we rely on an administrative code or a discontinued program by the post office to disenfranchise our voters. I have nothing further.
Thank you, Mr. McDermott. You have 15 minutes for rebuttal.
Thank you. With respect to the change in Intelligent Mail barcode tracing now being part of the post office's visibility system, the word that the post office used was migrated over. The tracing process is going nowhere. That ability is still available. The Wenatchee County Auditor was only able to get the information from the post office's spray painted codes with a court order. There is nothing that requires the post office to provide the information on the spray painted codes that would result in a consistent, verifiable process for us to use the spray painted codes and try to determine the origin date. Concerning the argument that technical terms must be defined in the Iowa Code in order for them to be labeled technical terms, we disagree that that is what Iowa law provides. In fact, to the contrary, Iowa law provides that the administrative agencies may define substantive technical terms that are in the Iowa Code. And in fact, here in HF 2273, we have expressly seen that the legislature granted the Secretary of State that power. Again, the reason that we've set up the law in the way that we have, the way that this legislature has, and the way that the Secretary of State has, is to put in place a consistent, verifiable way to operate elections. And by using a code process or a code system that is something other than the IMB tracing system or some similar process that provides us real-time verifiable data about it, we have no consistent, verifiable way to ensure that votes are properly being counted. Thank you.
Thank you. So at this time, the committee will begin questions, starting with me. Ms. McCormley, Iowa Code 53.17, Item 2 states, and you've talked about it, I think, in your statement, in order for the ballot to be counted, the return envelope must be received in the commissioner's office before the polls close on Election Day, or be clearly postmarked by an officially authorized postal service, or bear an intelligent mail barcode traceable to a date of entry into the federal mail system not later than the day before the election, and received by the commissioner not later than noon on the Monday following the election, unquote. Do you know when the 29 ballots in question were actually received by the county auditor? Do we know that? Were they received all at once? Were they different days?
We know when they were received. They were each stamped by the Winneshiek County Auditor on the date that they were received. I do not recall when all 33 were received. I know a majority of them were on the 7th. 2 of them were even closer to the canvas, but I can give you that information. It is on each of our exhibits 1 through 33.
But they would have all been received, obviously, before that requirement of noon on Monday after the election, obviously.
And there is an extension when the Monday after the election is a holiday, as it was this year. But yes, it was prior to the close of the canvas.
Okay. And obviously they weren't postmarked or we wouldn't be here, correct?
Correct.
Okay. Do you know which on the ballots, what was actually used to determine the date that they were put into the mail system?
I do not know. All I know from the auditor's report is that they used a barcode. There are several barcodes on each of the mail pieces, and that would be testimony that the auditor would need to provide.
Okay. And when we're talking about this barcode that's on there, it's not, we've had a discussion and disagreement on intelligent mail barcode, but as far as the one that would need to be purchased and you pay a certain amount per envelope for, and that is initiated by the mailer, the barcode that we're talking about, it is my understanding that in some towns where the envelopes or the mail in that town actually doesn't go to a postal hub, but it stays within town, they don't necessarily put that barcode on there. Do you have any information about that? In other words, it may not be consistently used.
My understanding is that there's a lot of different issues with, there's actually 3 barcodes, our understanding is, on each ballot. 1, I think, is an internal use of the auditor, and 2 were placed by the postal system. The scans that were provided by the auditor are not clear enough, but he has verified, and people who saw the ballots agree that there is also a faint pinkish orange one on the back as an additional one you cannot see in the images. I know that there's other issues even with the tracing program. Some of the auditors have said they also have had some issues where they cannot track those ballots.
Okay. Thank you. Just a couple of comments that I would make in researching this. I was here in 2016 when the intelligent mail barcode system was initiated by House File 2273, I think Senate Amendment was H8205, that established the use of the intelligent mail barcode. During remarks on the floor of the House on April 20th, 2016, Representative Lee Hine, in encouraging adoption of the amendment that would establish the use of this intelligent mail barcode as an option for auditors when there wasn't a postmark on them and we're trying to get as many counted as possible. He stated, quote, it was specific to that particular envelope. He went on to say, quote, they can track that at the post office and can actually tell the auditors when the envelope was put into the mail. Also, Senator Danielson, I wasn't in the Senate, obviously, when he made those statements, but I went back and reviewed that as well as I was preparing. I also went and looked up the definition of intelligent mail barcode on the post office website. One of the descriptions is a 65-bar Postal Service barcode used to sort and track letters, and there's a longer definition as well. I know that the intelligent mail barcode that has been discussed today has a 5-digit number on the top left corner below the address, which also is in those bars, those 65 bars, and that tracking number allows, it is specific data to that envelope and nothing else. And that the intelligent mail barcode, you have to purchase that and it's initiated by the mailer. So I know from being here during that debate that the intelligent mail barcode was a specific type of proprietary product that we were giving that option to because of the tracking that was involved. And it had to be initiated by the auditor, and we made that optional because, and I think there's 7 counties now that are doing it, was my latest count. We made that optional because of the cost involved with those individual envelopes, and it was something that was initiated by the mailer. So I do have a clear understanding of what the legislative intent was for that intelligent mail barcode because I was there, and I listened to the debate. So I do have a very clear understanding of what that is. I would also mention, let's talk about a little bit the use of capital letters in the Iowa Code. I consulted LSA as I was doing my research on this issue. And Legislative Services Agency, when they publish the Iowa Code, they have very, very distinct rules that they follow as far as abbreviations and numbers and capital letters are concerned. The list of capital letters, things that they capitalize in the code, does not include a noun. And so the term intelligent mail barcode has small letters in the code. However, the administrative code, which was done by the Secretary of State's office, who knew exactly what intelligent mail barcode was intended to mean, it is capitalized in administrative code. I do understand and am going to give some great thought to what you've spoken about as far as the fact that the system is now called something else and has migrated to something else. So I do appreciate that information. I would also mention that Senator Danielson has filed a bill just within the last 24, 48 hours that would allow any barcode on an envelope that can be read with a date to be used in the next election. So I think that also sort of confirms what was intended in the code at the time that this legislation was enacted. Thank you very much, and thank you, Representative Meyer.
Thank you.
Thank you.
Okay, I have so many questions. I've never gotten to do this with another lawyer, so I appreciate this. You're getting a little taste for your own medicine. Sure. Mr. McDermott, you made a stunning closing statement, and I think it began with something like the fundamental question. Could you restate your closing argument, your closing sentence? Or just summarize it?
Yeah, it was the fundamental question here is what this legislature intended by the term intelligent mail barcode. It's up to the legislature to decide the meaning of its own phrase here.
You stated, let me just, what I wrote down, and this is just going to be summarized. You stated the fundamental question here is, does Iowa law allow the counting of ballots without this system? That's a stunning stunning indictment of the law. It's a stunning indictment of the fact that we have several counties, including Fayette County, that did count these ballots without an intelligent mail barcode. So is your assertion that anybody that counted these ballots and they did not use what's the proprietary term of intelligent mail barcode, is your argument that those ballots should be tossed?
It's my understanding that Fayette County did not actually have the barcodes read. They simply were received, and they didn't go to the post office. They didn't have intelligent mail barcode tracing, so they couldn't download any information about them.
They did, in fact, count those ballots.
That's my understanding that they did.
That is a Republican county auditor, correct?
I don't know.
Okay, that's a county auditor. Winneshiek County is a Republican county auditor. Doesn't that create, based on your education, an equal protection issue if one county auditor counts ballots without running them through a system and another county auditor requires that they have this very specific proprietary term used on the barcode? Is that at all concerning to you as an attorney?
I'm not entirely sure what happened in Fayette County that caused those ballots to be counted. As a general matter, I believe that the law is very clear as to what absentee ballots can be counted and which ones can't. And it's my view that the Winneshiek County Auditor has done exactly what he was supposed to do here. As to what the Fayette County Auditor did, I'm not entirely sure.
Is it fair to say the intent of the language in the code is to make sure that ballots that arrive, just not so much the language in the code, but the intent of the code and the way it's written is to make sure that ballots arrive on time, they're in the system on time, they're in the auditor's office on time. It's essentially the intent of the legislature, I hope, that those ballots be counted.
I think that it's a balance of different interests. There is that, certainly. There's also the balance with that, though, of making sure that you have an accurate, verifiable, sound election process. And to do that, you have to set up rules that are going to mean that some ballots are in and some ballots aren't. But I think that it's a balance.
The balancing test, then, is a very technical term and a very tight interpretation of what an intelligent mail barcode is and a proprietary term versus your constitutional right to vote. That's the balancing act.
I wouldn't describe it in that fashion. I think that the rules that were put in place, the statute and the rules that were put in place around it relating to use of the intelligent mail barcode were done in a way that makes it a verifiable process. In other words, it's not, there is a specific process in place for those that use the intelligent mail barcode tracing program to get the results from the post office in a way that can be replicated and in a way that you can verify. And I think using a different sort of barcode on the envelope doesn't permit that. At least it doesn't yet as far as we know.
Okay. You would agree that it's a longstanding principle in this state that legislative debate statements by individual legislators cannot be used for the purpose of deciphering legislative intent. You'd agree with that?
In interpreting statutory construction, there are a number of things that can be used, and courts certainly have used that.
Okay. I'm curious because the abortion debate that was used has everybody all over the place on that, on intent.
And it's also in the collective bargaining
Sure,
case, too.
collective
Yeah.
bargaining, sure. You would agree that lawyer statements are not evidence?
I would agree.
Yeah, and witnesses if we were allowed to have witnesses and call witnesses, that would add color and context to the exhibits.
I'm not entirely sure that it would add much on the very specific legal point that we're talking about here. As you know, in the summary judgment process, there are material facts that are relevant to the legal issue that's before the court. And I think that this is a similar issue, that this is a situation where I think we have all the factual record that's necessary to make this determination. I think the legislature can determine what the legislature means by its own words and phrases.
Okay, that's interesting. You would agree that some of those ballots that we were examined, those 29 ballots are military ballots, and those are counted different, correct?
Counted different in what way?
The military ballots are counted very differently than just random regular ballots. You understand that? And some of these were military ballots.
It's certainly possible some of these are military ballots. I'm not sure what you mean by counted differently. You mean in terms of the time?
Trust me, they are.
Okay,
Yes.
all right.
We're going to play word association or word game. Barcode. What's your definition of barcode?
I believe a barcode is in general, is a code of, is a string of vertical lines of various lengths.
And what's your definition of the mail? Mail.
Mail, I guess, it could be a noun or could refer to a system. I think in this case, it refers to a system that's operated by the Postal Service to move letters and packages from one place to another.
And so what we don't know is the definition of intelligent. And so these 29 ballots and the people that voted, their enfranchisement hinges on the definition of intelligent. Is that fair?
I think that the three words in tandem are a technical term and frankly a term of art. And so I'm not sure that in dividing that phrase up, we get to the right result.
I'm looking at Exhibit 4, which is your Exhibit 4. And I'm looking at this little R. What does the little R there mean?
It means registered, and it refers to a registration made with, I believe, the Federal
Trademark.
Office.
So this very defined or very specific term is registered trademark. I, capital M, small b, capital T tracing is a registered trademark. Can you show me anywhere in the code where this term is in regards to this contest here, this registered trademark?
That term is not in the code explicitly. As Representative Holt mentioned, the LSA in use of capitalization, and it's our Exhibit 12, if you'd like to look at it, is, has a very specific use of capitalized terms. In fact, Iowa State University, well, you don't have to put it up, Angie, but the word state is not capitalized. The word governor is not capitalized.
Can you show me anywhere in the code where it uses any registered trademark language?
Offhand, I can't.
Okay, but this is a very specific proprietary United States Postal Service product. And you would agree that this registered trademark, very specific proprietary product is not in the code.
There is no use of the registered trademark term in the Iowa Code. I do agree with that.
And you would agree that we don't have, well, you don't know, but I can assure you there's no other place in the code where there's proprietary language used on a trademark or anything else. So barring that in technical terms and your reference to 4.1 subsection 38, yes, we do have very specific ways we define those terms, technical words, but those technical words are lumped together in plain meaning, but there is never any definition that's ever used a registered trademark in the Iowa Code. In fact, it's not allowed. In fact, capital I, capital M, small b is that registered trademark, presumably, because it has the R by it, and that is not specifically listed. Anyways, again, you would agree that barring that, it's the specific language, even though 3 letters are often lumped together within the code, they don't necessarily mean a specific registered trademark that's used by the Postal Service. You would agree with that?
Well, I again would agree that there's no registered trademark term in the code. That said, I think that the legislature had something very specific in mind when it passed this. I think that that's borne out in the admin code. And I think that, frankly, by virtue of the fact that they did not perhaps want to use a very specific registered trademark term is perhaps why the language that was used was chosen.
And just to double back on other counties several different counties counted these ballots very differently. And these ballots, what we use in legal terms and constitutional terms in equal protection is similarly situated, similarly situated occurrences. So in this case, one county that had similarly situated ballots that came in later, just to reiterate, to double back on, versus what Winneshiek County did, they counted them differently, correct? Used different protocol to count them.
Correct. The counties that had the intelligent mail barcode tracing were able to count ballots that other counties did not.
Okay, I'm sorry.
I was just going to say, I do not believe that that's a violation of equal protection.
Right, but voting is a fundamental right, and any impediment to voting in legal terms, when you're dealing with fundamental rights, you'd be dealing with strict scrutiny. And when you deal with strict scrutiny, as Mr. Winchell knows, when you deal with strict scrutiny and fundamental rights, that is, you have to have a compelling government interest. What is the compelling government interest here in not counting these ballots?
Well, I don't think that the analysis works on strict scrutiny as it relates to the difference between some counties using intelligent mail barcode tracing and other counties not. I disagree with the statement that there can't be limitations on voting. Of course, there are, right? I mean, there are limitations on the day that you can vote. Other counties have satellite voting, while other counties don't.
Thank you. That's all the questions I have. If you allow me, I think you made some statements, I'll make some statements. Sure. I think we really need, in this contest, to hear from witnesses. I think we can color the testimony and the exhibits with witnesses that perhaps we can call Fayette County's auditor, we can call Winneshiek County's auditor, we can find out what they did, how they did it differently, why they did it the way they do. Again, we do not put proprietary language in the code. It's never been done. Nobody can point to it, not anybody at this table. Finally, I'd say that in the end, I hope we do call witnesses. I would like to call Mr. Bergen as a witness and ask him, I think the fundamental question to him is, should these ballots be counted? Does he believe in democracy? I hope we will be able to call him as a witness and ask him that. Thank you.
Thank you, Representative Meyer. Representative Jacobson, you have 15 minutes.
Thank you, Mr. Chairman, members of the committee. I won't be long, but I'd like to bring perhaps some more clarifying focus to this hearing today here. I don't believe we're here at this juncture to make assertions. I think we're here to ask questions and listen, as this is an evidentiary fact-finding enterprise in which we're undergoing at this juncture. My only comments that I will make, other than some questions, are that I want to express my great admiration to both candidates. In the Theodore Roosevelt arena, both of you have gone extra rounds in the battle, and the stamina and the dedication that you've both shown are tremendously edifying, and I think we would be well served were either of you to be seated here on a permanent basis. And I congratulate both councils, very well prepared. For my clarifying purposes, I do have some questions. I'd like to ask, I'll just start on this side, go to the other. We'll probably have some back and forth with the councils here. Ms. McCormley, I'm trying to zero in on what's the appropriate controlling legal standard to adjudicate this, so to speak. We're gathering facts today, but we've heard a lot of arguments, but what do you believe is the appropriate controlling legal standard that we should be using here on which to make such a decision at this juncture?
Well, additionally, I think that we need to have an appropriate legal process that's followed from Iowa Code chapters 57, 59, and 62, which contemplate subpoenas, witnesses, and testimony. There's been arguments made by both of us, and while I'm sure we both have tremendous credibility, we're attorneys, and we are spinning things for our clients. There's questions about what happened in Clayton, or in Fayette versus Winneshiek, and I think the standard here needs to be, what is Iowa law? We're not talking about tracing. That's not the issue. LSA would have known to define these terms if that's what it meant, and going into what Iowa Code says.
And am I fair in characterizing then that your prime element of focus is the Iowa Code, the Iowa statute in play?
Yes, and the Constitution.
Okay. Of Iowa?
Of Iowa and the United States Constitution. They
Very
both
good.
guarantee the right to vote.
Okay. Thank you. Mr. McDermott, do you agree? What do you think the appropriate controlling legal standard is? And my good colleague, Mr. Meyer here knows that that's a term of art, but what's the legal standard that we're really trying to puncture in on here?
Article 3, Section 7 of the Iowa Constitution says that it's up to the legislature to determine the qualification of its members. And so I believe that it's that section that would be the guiding section. For that reason, I also think, by the way, that there's no appeal right here. I think that that's been settled in Luce v. Ray in 1977. But I think that the Constitution is the authority to determine the qualification of members of the legislature.
Do we have a central agreement between council that the appropriate controlling legal standard would be the Constitution and the statutes of Iowa? Are we on agreement on that?
I agree on that. I do not agree on the interpretation that there's no appeal right.
Right.
Yes.
That caveat aside, do you think that that's a reasonable characterization that I've just brought forth, the Constitution and the Iowa statute?
Yes.
Okay. I'd like to ask Ms. McCormley specifically, you alluded to it, but where in the U.S. Constitution are you looking specifically for directive here?
Well, it's the fun of the two issues, constitutional protection that the Iowa Constitution also includes, is the fact that voters have a right to vote as long as they follow the laws, and that when any of the, I don't know if I want a trial, but a tribunal, there's the right for equal protection for the voters and the right to the trial with due process.
So you're looking at a traditional 14th Amendment argument. Would that be a fair characterization?
For those, yes.
Okay. Mr. McDermott, do you believe that the United States Constitution enters into deliberations here in this circumstance, specifically a 14th Amendment issue?
In this contest, I do not. I think that this
Okay.
is a straightforward application of Iowa law, and I think the legislature is able to determine what it intended with the words intelligent mail barcode.
Okay. So we have a point of specific disagreement here, an appropriate legal standard with respect to the constitutional issue. That's helpful. Ms. McCormley, any U.S. constitutional case law that you're hanging on to for support in your constitutional argument that you're looking at this juncture?
I mean, not at this juncture. That becomes an issue if this committee does not hear evidence and provide my client due process as required by the Iowa Code, which was put in place to enact the Iowa Constitution. And then the other issue is if these voters have an equal protection right because Fayette County did count them. So at this juncture, no, that would be the next step.
Okay. Let's take a look at administrative law and the administrative agencies, the administrative code. Now, Mr. McDermott, you made an argument that proper deference should be given to the administrative agency in this circumstance. Could you elaborate upon that just a bit more for us here for our edification, please?
Sure. In the House File 2273, the legislature made clear that it was providing rulemaking authority to the Secretary of State. So in other words, saying we want to get these in place quickly, and I think you heard Senator Danielson mention that too. And so when that happens and the agency puts in place rules, those rules, as a matter of statutory construction, have more weight than they otherwise would.
Okay. And tell me why you think in this circumstance reasonable deference should be given. Is that because it's essentially the default position at law? Is that your contention?
It is in part because the crux of the issue before us is the definition of intelligent mail barcode. And that is the agency that has the expertise in dealing with this issue.
Okay, thank you very much. Ms. McCormley, I was interested, you had a different take specifically on the administrative rules and protocols here and did not give as much deference to that. You actually had an issue with it. Would you elaborate for me, please, a little bit of your thought processes there?
And maybe if that's the impression you had, I misconstrued. I don't believe that the Secretary of State does not have the ability to enact guidance on how to implement. What I believe, number one, is we're talking about two different things still, because the administrative code is still on tracing. And so I'm not giving deference to that particular administrative code on tracing when the Iowa Code does not discuss tracing. So I'm not giving deference to a definition when that was not the plan for that administrative code. The other issue is that you cannot change what this legislative body has passed, the governor has signed, through an administrative rule. That is my second issue. And so if we are now using that particular code to say the only time we can ever use an intelligent mail barcode is for tracing, you can't change the law with an administrative rule.
Okay, that bifurcation is very understandable. Thank you for that. Let's go to legislative history a little bit. I was not here in 2016. However, I have done some due diligence in depth on the legislative history. Mr. McDermott, we saw a video of the Senate debate. We did not see a video of the House debate. Chairman Holt alluded to it. Are you familiar with the legislative floor debate and bill history with respect to the House voting on the bill in 2016?
In a very cursory way.
Okay.
But I've not seen video of it.
Sure. And in the Senate, where we saw that clip, what we didn't see was the vote total afterwards. Do you know, was that a bipartisan passed bill?
Yes, and I was running low on time, so I had her cut it off.
Right.
They actually, on that video, if I would have let it go 5 more seconds, they had a voice vote, and I believe it was unanimous in both houses.
To what extent do you believe that deference should be given to a formal record of floor debate is impacting and informing legislative intent? To what extent do you think that is germane and appropriate?
I think it can, and I think courts have said this, it can depend on the circumstance. As a matter of constructing a statute, it is not top of the list, but it is on that list. And I think, from my vantage point, when you look at everything on that list, it all points in the same direction here. And so I view it as one more thing to point to what the legislature intends by the use of the words intelligent mail barcode.
Okay, thank you. Councilor McCormley, the House debate itself, we are a bicameral legislature, and I like to tease my Nebraskans that it's far better to their unicameral situation there. But the House floor debate, can you inform me at all a little bit more, perhaps objectively, as some of these colleagues of mine were there, but what's your analysis of the House floor debate in terms of legislative background for the bill, please?
Well, and I also have not seen a video of it. My understanding that it was also unanimous, and that there was not maybe perhaps as much debate about what this program could be used for. Speaking with members who were present, this was not a contested issue, and that it was working with barcodes, that it wasn't quite so narrow as perhaps now we are talking about.
Right. Thank you very much. I know Mr. Hein and Mr. Hunter were both involved in the video and transcripts of that. Do you think that that is properly informs and brings weight and bearing to the intent of a legislative body with a floor debate and then a vote taken after that?
I think it definitely can. I also think we have to be careful looking at one elected official who is voting on this. We have 150 who voted and a governor who signed, and so they had different intents. And so we cannot take one and make it count for everyone. I will say that some of the members I've spoken with have a different interpretation of kind of how that was presented, and that just statements made by one person cannot now be attributed to everyone. It can be informative, yes.
Sure. The whole IMBC discussion in those both Senate and House debates, I'll continue with Ms. McCormley for just a minute. Is it your opinion that those were generic discussions in those transcripts or more specific to a unique type of traceable IMBC?
I think the information that was presented at that point was, hey, the Postal Service has ways to read their barcodes, and let's go ahead and do that because we'll allow more votes. And that was a compromise that was agreed upon and put into the bill.
Thank you for your opinion on that. Councilor McDermott, I am curious. You showed the Senate discussion. You proffered that showed a specific, almost uniquely identifying type of IMBC. Can you elaborate on if you think that I guess I would just ask you, why do you think they drilled specifically and correctly beyond a generic in that discussion? What makes you think they were talking specifically about a volitional traceable system?
Because there is no other way to use a barcode that permits you to have access to the information. It is the only path that I know of to get it. Using the barcode that is sprayed on by the post office does not allow a sender, a mailer, to get that information. You just can't get it unless you go to the post office and ask for it, or in this case, unless you get a court order for it. But there's no ready way to get it. And so I think that that's why the discussion at all times dealt with the intelligent mail barcode tracing, because it permitted them to get that info.
Okay. 1 minute left. I just want to verify, are both councils in agreement that one county counted votes without verifying anything, Fayette, one counted votes that in Clayton that only counted the IMBC traceable, and one county did a count of vote that is basically not IMBC traceable? But that is what you're asking for in Winneshiek.
So for clarification, Clayton County had 3 ballots that came in and all had postmarks, is my understanding. The auditors could explain that better, and so I do not think they used the tracing system either.
Okay, so we have one traceable, one non-traceable at this juncture, and one where they just allowed the ballots in. So you've actually got 3 different paradigms in a way.
Yes.
And I'm not that familiar with what happened in Fayette County. I know what happened in Winneshiek, and I have an understanding of Clayton, but the Fayette one, I'm not that sure about.
Thank you. Thank you, Representative Jacobson. Representative Winchell, you have 15 minutes.
Thank you, Mr. Chairman, and thank you everyone for being here. Just a couple quick questions. Mr. McDermott, in Exhibit 14 in the binders here, are these the actual photocopies of the actual ballots that in question?
Yes, they are.
Why do they all have postmarks on them?
Why do they have postmarks?
Yes.
So that is a type of postmark that is, it is called a non-postage canceling postmark. And a postage canceling postmark, one that goes over the stamp so you can't use it again, has a date on it. That postmark does not have a date on it.
Okay, that answers that question. When these ballots were in question, and I guess this will go to Ms. McCormley, when the judge ordered for these ballots to be taken to the post office and processed to see if they could be verified at what time they were mailed, who took those ballots to the post office?
I have not received any other information from the county auditor and his counsel other than the report that was filed with the court. Although voting records are open records, we have been denied knowing even which of the 29. I don't know who took them or even how the process was done, but I know that it was done despite the fact that they're saying there's no way. They took them, they have the information.
Okay, Mr. McDermott, do you have any follow-up answer to that? Do you know who took the ballots to the post office?
I do not, and the only record that we have of it was a filing made by the county auditor's attorney in the district court case. So we don't have an affidavit even from the county auditor on that issue, I do not believe.
So, and I'll pose this question to both of you. So in this election contest, when the votes were recounted, there were 3 witnesses, one by each party, and then an independent person that was appointed by the county auditor, or whatever that process is. There were 3 people that were standing there bearing witness to the recount of all the ballots, correct?
Correct.
Yes.
Okay. But there were no witnesses, and we don't know who took the ballots to the post office. Do we know who ran the ballots at the post office?
We
do
have
not.
no information about that.
Is there any evidence of chain of custody?
We would need to call witnesses.
Okay. Okay. All right, Ms. McCormley, this question goes towards you. In your client's affidavit of contest, in bullet point 9, it says none of the 33 ballots contain stamps canceling postmarks, but did contain intelligent mail barcodes. Are you contesting, and I know we've heard a lot of different discussion here today, are you contesting that the barcode at the bottom of these facsimiles here, that's an intelligent mail barcode?
It is our statement that the post office was able to read one of the 3 barcodes on the mail, and that makes an intelligent mail barcode.
But does this barcode at the bottom of these envelopes, does that meet the standard definition from the United States Postal Service for intelligent mail barcode?
Well, when we stated it, we're saying it with Iowa code. Does this comply with what the post office defines? I don't know. It doesn't seem that it does for their tracing program, but it does for Iowa law.
That's your assertion that it does for Iowa law?
That is our assertion.
Okay. As we look at the code, 5317, I don't mean to beat a dead horse here. We all know what it says. We've heard it time and time again. It has to have the postmark or bear an intelligent mail barcode traceable to a date of entry into the federal mail system. You're contesting that, and again, this is for you, Ms. McCormley, that if we just take the code and apply that to this case, and we do not adhere to the administrative code or the rules that were crafted to implement this section of code, that is what you're saying we should do here today. We should just take this code, say that that intelligent mail barcode that it references in here is the barcode that's at the bottom of these envelopes.
I have not said anything about disregarding the administrative code. The administrative code talks about tracing. The Iowa code does not talk about tracing. It's a different program. The administrative code doesn't define intelligent mail barcode either. So I am not saying that we disregard any other, the administrative code. It's a different program. It allows the auditors to use that program. And we are saying that the barcodes on these 33 ballots allow the auditor to obtain the information necessary under Iowa Code 5317.
Okay, then you can't speak to intent, but I'll ask the question, and if you'd like to respond, you may. Then when we have the code or the rules 721-2114, intelligent mail barcode tracing, why was that written if it not to implement code section 5317 or the entire chapter for that fact? What is that? What is the intent of the intelligent mail barcode tracing in the rules, if not to implement the code?
It allows the tracing system to be used. Voting is a fundamental right. And when you're using different technologies, there needs to be authorization and security. There's a lot of the different parts of the administrative code making sure that the voting machines are secure, which ones they can use, and implementing Iowa code. That does not define Iowa code. It allows an easier way for the auditors to trace the ballots. It is talking about a specific electronic system that the Secretary of State is saying may be used in the voting process.
Okay. But what you're saying is then we have two different standards between the code and between the rules.
I'm not saying that. We can use intelligent mail barcodes as are on these ballots. And as Mr. McDermott keeps saying, we don't know how the auditor is going to do this. His brief is full of questions. If the auditor doesn't want to have to go to the post office to get the information, they may pay and have the system in their own office. There's not two different standards. There's different ways of having it done. Auditors implement their responsibilities in different ways for mailing, for other things that they need to do. This is a secure way that the Secretary of State said they can use this electronic system offered by the post office to implement this code. Not the only way, but a way.
But there's nothing in code that authorizes any auditor in the state to take ballots out of the county courthouse and take them down to the post office and check them. The only reason that happened in this case was because there was a court order to go see if they could verify. And in the 33 ballots, only 29 could be verified technically, but we still don't know how that process was run through. So I guess that's where my confusion lies, is that I've seen plenty of legislation passed, and we give one agency or another, or one department or another, rulemaking authority to implement that law. That's what happened in this case. That's where we have 5317, and the rules back that up, and that is the definition of intelligent mail barcode. And through the testimony I've heard here today, the marks at the bottom of these ballots, this is not an intelligent mail barcode as described in the rules and as defined by the United States Postal Service, and that was the intent of the legislature. So I appreciate your responses, and so thank you for that. Well, it's too bad Representative Meyer left the room. I was going to bring up the fact that he's talking that intelligent mail barcode, and in some of this discussion we've talked about that we have to use just the general interpretation for intelligent mail barcode, and then not use the interpretation or definition for what IMB is in the rules. Well, quite frankly, in Chapter 724.9, we refer to the National Rifle Association when it comes to qualifying for a permit to carry weapons. Everybody knows what the National Rifle Association is. There's no vague ambiguities there. So there are places in the code and instances where we refer to something very specific that is a trademark, is not trademarked in the code, but yet everyone knows what it's referring to, and we still adhere to that standard. No, I was just merely pointing out that there are places in the code where trademarks are not used in reference to other proprietary names and or information and technology. What this boils down to, and this is not easy for anybody, it really isn't, but this boils down to whether we're going to adhere to the rule of law or not. We've got 5317, we've got the rules that back it up. We've got the evidence before us that says that these are not intelligent mail barcodes, and I want to make sure this is clear. So, Mr. McDermott, on the bottom of these facsimiles for the ballots, is these hash marks, is this an intelligent mail barcode?
I do not think that that's an intelligent mail barcode for purposes of Section 53.17.
The way the United States Postal Service defines intelligent mail barcode, would this qualify as an intelligent mail barcode?
It depends on how you define intelligent mail barcode. For their purposes, is it possible to scan it and get data? Yes, it is. Is it something where a mailer can determine that information? No, it is not.
Okay, and so with that answer, that would comport with what we have established in rules as far as what county commissioners can use as in the definition for intelligent mail barcode to track ballots.
Correct. HF 2273 makes no sense as to sections 15 and 16 if we can use any barcode on any piece of mail.
Okay. I don't know if any of the other members of the committee have done this. I actually reached out to my county auditor. She's been a county auditor for many years, and I gave her the circumstances of the case. I'm not going to mention her name, but I asked her, I said, what would you do in this situation? She's told me before, this situation has arisen. It's not been where there's been an election contest, but where ballots have come in with the Postal Service barcode, but not intelligent mail barcode, and she's told me they do not count the ballots. I'm sure that's probably true for many of the other county auditors across the state. So if we're talking about fairness in election and equality and making sure that we're following a set of standards that everybody can adhere to make sure that everyone is treated equally, I think that's what our county auditors are doing. I think that's what happened in this case, but I'm still going through all the information. At the bottom line, like I was saying, the rule of law has to apply here. When this got kicked back to us by the court, the judge said very specifically in his conclusion, as part of the House of Representatives' duty and responsibility as a contest court, it will need to determine the meaning of intelligent mail barcode under Iowa Code 53.17, paragraph 2. The evidence is before us. We'll have to make our decisions, but we have to apply the rule of law out of fairness and equality for every vote that was cast in this state. There were other ballots in other counties that had this exact same hash mark at the bottom, did not contain a postmark, and was not IMB traced, and they were not counted. It happened across the state this last election. County auditors, both Republican and Democrat, set ballots aside or cast them out in this exact same set of circumstances. And nobody has said anything about those ballots yet. So we have to apply the rule of law, whether we like it or whether we don't. The rule of law has to stand. Thank you, Mr. Chairman.
Thank you, Representative Winchell. Representative Wolf, you have 15 minutes.
Thank you, Mr. Chairman. And I also want to thank the candidates and council for being here today. And I agree, you've done an excellent job of presenting cases, for arguments. I realize you're not actually in a position to present any evidence, but we may get an opportunity to hear that. So, oh, I'm sorry. I can't do that. Mr. McDermott, when Representative Winchell asked you, is the barcode on the bottom of the ballots that we're dealing with, is that an intelligent mail barcode as far as the U.S. Postal Service is concerned? I think you indicated that, well, it could be for some purposes, correct?
Yes.
And would you agree that those barcodes, whether, whether pursuant to something the auditor does or something that the post office does, from those barcodes, the date that the ballots were introduced into the Postal Service was able to be determined?
I know very little about how they determined the dates of the origin into the mail system, but it's my understanding that the post office can do that.
Okay, and we seem to have an affidavit somewhere in this evidence where the auditor, swears under oath that in fact the information he obtained from the post office that they obtained from the barcodes indicated that they were introduced into the postal system in a timely fashion, correct?
There's a filing from his lawyer to that effect. How the post office, what it read, how it went about reading the code, the barcode, I just don't know.
Okay, so that is certainly information that some of us might consider relevant, but neither you and Ms. Cormley, do you have that information about exactly how the ballots got there, what was done with them, how this information was developed?
I do not.
Okay, thank you. So, Mr. McCormick, and I'll be asking you both questions, but if in fact, hypothetically, the date of mailing, an inaccurate date of mailing was able to be obtained from these barcodes that sometimes, I guess, the post office does in fact call intelligent mail barcodes, then for this case, not across the state, because we don't have other counties' elections, other district elections in front of us. We've just been asked to decide this case. So for this case, what is the compelling government interest that would support taking the position that, well, yes, it's a barcode, yes, it was intelligent enough to provide us with the one piece of information that is relevant to the issue before us, i.e., did they make it or were they mailed in time? What's the compelling government interest that would justify insisting on interpreting intelligent mail barcode in such a way as to invalidate those votes, the votes of those 29 Iowa citizens?
I think we have to have a uniform process to look at the ballots that come in after Election Day. And we have that process in place. And I don't think that it is appropriate to, in one specific case, after the election is over, to change the rules, to
Well,
make an
that's-
exception for one case.
I thank you. But I mean, nobody else has brought this challenge, correct?
To my knowledge, none have.
And you'd agree that the way we make new law is by, I mean, somebody looks at something and realizes there's a problem, it's not constitutional, nobody else has ever raised it before, so everyone else in the past has been arguably had their rights infringed upon by that code statute, the way it was being interpreted, but somebody raises it, and at some point, whether it's a court or a legislative committee, somebody decides that that the way it is being read is illegally, overly restrictive on somebody's constitutional rights, right?
I would leave it to the legislature to decide whether this needs to be changed or clarified. But I think, as it stands, the law is clear that these votes should not be opened or counted.
Well, the law is clear if we accept that the only possible definition of intelligent mail barcode is what's in the administrative code. I mean, wouldn't you agree that it's possible that it means both? That, you know, that the main, it seems to me that the only job of this barcode, it has one job, and that job is to reliably inform us of the date that the ballot was put into the mail. That's its only job. And there's different ways to do that job. There's different barcodes that can do that job, and I guess it sounds like one barcode or one system is the one that's in code, and, you know, that may be used, is not required to be used. But there's another kind of barcode that was used in this case that does provide that information. And I guess, I mean, so the fact that this says you may use this system, which is easier for the auditor and maybe makes everything simpler, is it your position that that means that you can't use any other type of barcode?
I think that Section 5317 sub 2 and the admin code and the legislative history all make clear what the legislature intended through use of this phrase. And so I think that using some other barcode that's on that's on there, that we don't know exactly, you know, what the purpose is, other than it's for the processing of mail, would not be proper here.
And we don't know what the purpose is, but I guess, do you agree that in fact, and I don't know if you do, but that in fact that barcode was able to provide, the barcodes on these ballots were in fact able to provide an accurate date on which the ballots were introduced into the postal system? Are you
And-
stipulating that, in fact, they were mailed at least the day before?
No, I'm not. I just don't know enough about that. I know that there was one filing made about it, how the process worked, what the chain of custody was with those ballots, what barcode they used, how they did it. I just don't know enough
Thank
about
you. I
it.
mean, I think that's very fair. I mean, we've been told that by kind of hearsay, but, I mean, would it be helpful to you if, in fact, we had witnesses come in and explain, experts with actual knowledge, explain exactly how the date of mailing was extracted from the barcodes on these 29 ballots?
I don't think so. And
Okay.
the reason is because I think that the legislature is clear that what it intended was intelligent mail barcode tracing, not some other type of barcode. And so what we're talking about here is using some other barcode on that piece of mail. And I don't think that we need to know anything about that barcode.
Well, sure, we may have intended one thing, but if in fact if reasonable people can disagree about what this means, what intelligent mail barcode means, then is there a reason why we wouldn't give the benefit of the doubt to the voters who did everything right, obeyed the rules, sent in their ballots in a timely fashion, made the effort to, get themselves registered and request the ballot and fill out the ballot and put the ballot in the mail in a timely fashion? If, according to this statute, it says that if an intelligent mail barcode indicates that it was received or it was mailed in a timely fashion, then it's eligible to be voted, why not well, never mind. I think you've asked and answered that, so I will withdraw that question. I want to ask a little bit about 57.5, because I am a little confused about this. 57.5 is in the chapter called Contesting Elections, General Provisions. And it reads that the parties to any contested election shall have the right in open session of, in this case, the tribunal trying the contest, and in the presence of the officer having them in custody, to have the ballots opened and all errors of the precinct election officials in counting or refusing to count ballots corrected by such court or tribunal. So, I mean, it certainly seems, when I read that, it says the parties to a contested election, so we have the parties, this is definitely a contested election. It gives them a right to have the ballots opened in open court. I guess, Ms. McCormley, do you interpret that as requiring this committee to allow the ballots to be opened?
I do. I think that requires both the ballots to be open for them to be brought down here. I also think that it's clear through Ms. Cater's due process rights and the rest of those code sections that despite we've talked about having testimony today, no one has testified. Neither one of us know what happened.
That's clear.
And so that's another right that is supposed to happen in this tribunal.
Okay. And Mr. McDermott, what do you say about the fact that this code section, which in fact is kind of links back to the constitutional provision you cited, which says that we're supposed to do this according to law, why doesn't that require that the ballots be opened?
I do not believe that 57.5 requires us to open the ballots. And the reason that I don't, it's called recanvass in case of contest. And it refers to the officer having to have the ballots opened, meaning the ballots, all of the ballots that were part of the election, not absentee ballots that were never counted. And it's not until you get to the second part that if there's an error in counting or refusing to count ballots, that you would open those. So I do not think that 57.5 provides any right to open absentee ballots that were never counted until we get to the next question, which we're dealing with here, which is what intelligent mail barcode means.
Okay. I don't know why you would open absentee ballots that have already been opened and counted. They've already been opened. I mean, are you saying that in order for this to apply to absentee ballots, it would have to actually say absentee ballots?
No, but Chapter 57 doesn't deal with absentee ballots in
Okay, it deals
particular.
with contested elections,
Exactly.
which is what we have here.
Exactly right.
All right, thank you. I guess I would just say that, you know, I really do appreciate, I do think reasonable minds can disagree, and I certainly feel that if that is the case, then why not interpret what is a ambiguous phrase for sure in a way that enlarges the scope of a fundamental constitutional right, which is the right of an elector, and you know, and then if we need to clean up code so that going forward we're on the same page, so be it. But this is one election. The code can certainly be read to allow the ballots to be counted if they left in time. And I guess, you know, when we hear evidence, I may hear a reason to arbitrarily restrict the voting rights of these 29 people based on kind of a semantics argument. But, you know, unless I see that evidence, I would be hard-pressed to vote to not count these votes when we all know they were mailed on time. So I'm looking forward to seeing and hearing more evidence about that, hopefully in the future. Thank you very much, Mr. Chair.
Thank you, Representative Wolf. We're now in that 5 minutes where if representatives want to ask a few more questions to clarify some things they've heard, they can do so. Representative Meyer, you have 5 minutes.
Thank you. First, to address Mr. Winchell, if you can find in the Iowa Code, where we cite to a very specific trademark name, I'll buy you lunch, buy you dinner. It's not there. Your statement implies that somehow we do this all the time. We do not. It's illegal. It's unconstitutional. You cannot cite to proprietary names in the code. Would you agree with that, Mr. McDermott?
I'm afraid I don't know the answer.
Okay. But this is the reason why we need to call witnesses too. I'd love to call the head of the LSA. And Mr. Winchell, I'd love to have a situation where you can show me, or somebody from the LSA, or anybody show me, where there is a stated trademarked, registered trademark name with the little R in the Iowa Code. It's illegal. You can't do it. Very specifically, you cannot cite to proprietary language. You can't say, everyone shall drive a John Deere tractor, or only John Deere tractors can be on the roads, right? You can't do that. It's illegal. That's why statutory interpretation is so very important. And you look at the plain language. The plain language is very clear. You stated it. There's 3 parts of that cluster of terms. They all mean very different things. Barcode, mail, intelligent. So, as I stated earlier, these 29 ballots and the enfranchisement of these 29 voters hinges on the word intelligent. Because we know what mail is, and we know what a barcode is. Yes, it does, because what I'm saying is, because it's very simple. If you have a proprietary term in there, it's totally unconstitutional. It's totally illegal. Nobody can say that you can do it. I challenge Mr. Winchell, you to do that. Finally, appeal rights. And 2 more things. What's the harm in calling witnesses if nobody knows how, why, the chain of custody on these ballots? Nobody knows. All we have is a report to the court, which I'll take at its face value, because we're all officers of the court as attorneys, that I'll take as face value that these, in fact, were mailed, however they found that out, whatever barcode they read, that as an officer of the court, you would agree, Mr. McDermott, that that's a factual statement, and if he lied about that, that'd be very serious consequences for that county attorney and that auditor.
I don't dispute that the lawyer that filed that believed in its truth. I just don't know how the actual info that is in that document came to be.
Correct. And it would be helpful if we had them come down here and explain it to us.
I don't think so. I don't think that's necessary because I don't think that that barcode has any basis to be read under Iowa law.
Finally, in terms of appeal rights, you're familiar with the 1975 case, 76, 77, whenever
Yes.
it finally came to the Supreme Court. That was a very, very different issue in terms of what the contest was about, in terms of the legal issue that was being contested. But the process was very similar to this. You would agree with that.
The legal issue was different. It was a collateral attack. It was not an appeal of what the legislature did.
But a legislature can act in many different ways. And when a legislature acts that's contrary to a constitutional right, that preserving and protecting those constitutional rights would take precedent over anything that's a matter of, in other words, this legislature, this committee could not pass a law that said only white people could vote, correct?
Correct.
And if they did that, we would have appeal rights to say
Correct.
the person that was affected. You're dealing with a fundamental right. You can't say only white people can vote, and that's an appealable issue, even though we've gone through the entire thing because those are constitutional rights. I disagree with your assertion that this is not an appealable issue because of those constitutional rights that were infringed upon. You testified that they were infringed upon by the fact that different counties counted ballots in different ways, and the fact that if we fail to provide due process here in this particular committee, in this process, by refusing to call witnesses, I think that is an appealable issue. Anything can be appealed. Anybody, that's just the way these things are.
Whether there's merit to it is a different question, but yeah.
Correct, but it is an appealable issue. Correct, I know what you're saying.
One could appeal it. I do not believe that there's merit to such an appeal.
I'm done. Thank you.
Would you mind turning off your microphone, Representative Meyer? Thank you. Representative Winchell, you in order for your 5 minutes.
Thank you, Mr. Chairman. Representative Meyer, I know you weren't here for what I said earlier. If I said something out of line to say that there was a trademark in the code, that was not my intent. What I was saying was, as we define intelligent mail barcode or reference it in 5317, the arguments laid out here have been that there's no true definition of that, but when we look at the United States Postal Service, that is a registered program. That is something that they use. That's proprietary information. You had made a statement in your opening to say that there was no other place in code, maybe I'm paraphrasing, so correct me if I'm wrong, but there was no other place in code that we reference something that has a trademark. I don't disagree with that, right? That you are correct. I believe that's against the rules or the law. But in Chapter 724.9, Paragraph B, utilizing instructors, and this is referencing the qualifications it takes to get a permit to carry a weapon. Utilizing instructors certified by the all lowercase, just like Intelligent Mail Barcode, National Rifle Association, and it goes on to list other qualifications. Now, nobody disputes when someone takes a National Rifle Association certificate into the sheriff's office and says, my NRA instructor certified that I completed the National Rifle Association course. The sheriff looks at that, they issue a permit to carry weapons if they meet the standards of the background check. So when we look at IMB, and then we look at what we were intending to do in 2016, and I'm not trying to speak for anybody else, but I was here and I do have a recollection of that. It was intended to go with the proprietary program the United States Postal Service had. Just like in the code here when we said that you can utilize instructors certified by the National Rifle Association. So to try and separate the two and say that just because this is lowercase or just because there's not a clear definition that says this is part of the United States Postal Service, I find that to be a stretch of what the law says and what the intent was in this situation. So that's what I was referring to earlier, not that there's a registered trademark and code, but that there are names referred to that are proprietary. The National Rifle Association is a registered trademark. Thank you, Mr. Chair.
Representative Jacobson, you have 5 minutes.
Thank you, Mr. Chairman. I want to go back to Councilor McCormley for just a moment. Just one question for you, and then we'll wrap up with one. The Iowa Administrative Code, 721, 2114, 53, 14.1, and 14.3. When they're using the nomenclature there, which is, and that's Exhibit 6, I believe, excuse me, Exhibit 6? No, Exhibit 9, Iowa Administrative Code 721, 21.14. Whenever it uses the phrase intelligent mail barcode tracing, the whole allowance for that seems to indicate that there has to be notice to the state commissioner of elections required, and the A, B, and C points on those are manifested. And then under 21.14.3, report to the state commissioner. Again, I know you differ with that. You don't believe this is exclusive. You believe it's a both and. Can you elaborate a little bit more on why you think this is not exclusive for using the post office purchased and outsourced barcode instead of the fluorescent wand, ex post facto review that you're arguing for?
Well, this is discussing tracing specifically, a program that has to be approved, a program that you have to apply for. Again, there's always concerns when we're talking about fundamental rights such as voting and using electronic equipment to make sure that it's secure and it's a good process. This shows that the Secretary of State has information and agrees that this is a good process to use. However, it's also been repeatedly said today, well, there's no other way to find information. How do we do it? This can't happen. It did happen. The Winneshiek County Auditor has put in a pleading, so I guess now we're calling him into question, but he did state that 29 of those ballots were placed in the mail timely. So clearly, there is at least one other method other than this tracing program to figure it out.
Okay, thank you very much. And then finally, again, I'm sorry. Okay, and just again, a fact finding, I'm looking at this District 55, and it appears right now what we have, correct me if I'm wrong, in Fayette County, everything got counted, even things that shouldn't have been. In Clayton County, only the IMBC verified USPO got counted.
In Clayton County, my understanding is they do not use the tracing system. However, the 3 ballots they received had postmarks.
Okay, so there's no issue there with respect to the IMBC.
Correct.
So that was not utilized at all, but no non-IMBCs were admitted. Is that correct?
That's my understanding for Clayton.
Okay, but for Winneshiek now, we're asking to count all of the non-USPO IMBCs. Is that correct?
I guess I don't understand what you mean non-USPO. The United States Postal Service put the barcode on the mail and they read it.
Oh, okay, I understand what you're saying. It still appears to me, though, that within one House district, we have 3 different modalities of counting. Would that be a fair statement? Specifically related to the way absentees, we're looking for future legislative action. It seems to me that even within one House district, we've got 3 ways that they end up counting these votes. Is that correct?
I don't think so. The way that Clayton did it is the way that you're supposed to do it. If it has a postmark, you use the postmark.
Right,
And
but that's one way. But the second way that Fayette did it, they counted everything. And the third way with Winneshiek, you're asking to count the ones with even the more liberal interpretation. So if we did this, we would have essentially three modalities of counting votes within one House district.
The way that Winneshiek did it would have been using the postmark, but they didn't have a postmark on them.
Correct. But what we're being asked to do today would offer yet a third counting modality.
Yes.
Okay, thank you.
Representative Wolf, did you want 5 minutes to follow up?
You bet I do. Thank you, Mr. Chair. And I realize we're here because there is a election contest in front of us. That's what I'm calling it, at least. But I got to admit, my focus to some extent is on the constitutional rights of the 29 or 33 Iowa citizens who, may or may not have, but it appears they did mail their ballots in on time and had a reasonable expectation that they would be counted. So let me ask Ms. McCormley, would you agree when we're talking about the rule of law, which is very important to all of us, that there is a hierarchy within the rule of law, and statutes, for example, trump administrative rule, correct?
Yes.
And the Constitution, it trumps statutes or administrative law, correct?
Yes.
So if a administrative code unnecessarily narrows the scope of the plain language of a statute, that would not be acceptable, right? That'd be a violation of the rule of law, because the administrative code is trying to legislate more than what we told them to do, correct?
Yes, that's what I think is happening in the definition that's being proposed by Mr. Bergen.
And if there's ambiguity in a code section, so reasonable people could disagree and nobody's exactly sure what it means, and some people think this or that, would you agree that if a fundamental right is implicated, then if there's any ambiguity, and you can read it so that 29 people get their vote counted or 29 people don't, would you agree that under the rule of law, it demands that we interpret that in a way that protects that fundamental right, if we have a choice?
That's why Ms. Cater continues to push this issue, because that fundamental right has been breached.
Okay, well, thank you very much. And again, I'm fascinated by this whole situation with the ballots finding their way to the post office and exactly what happened there. So, I really do think we get to hear that. I think that also might make us more confident in our decision. Certainly would make me more confident about in my opinion, ruling in the rule of law to ensure that constitutional rights are protected if I know that, in fact, these voters did do everything right. Right now, it looks like that's what the record will reflect when we get a record in front of us. But I am keeping an open mind and looking forward to hearing from some people with actual firsthand knowledge about this. Thank you, everyone. It's been a very interesting discussion.
Thank you. A couple of observations I would make before we adjourn for the evening. Ms. McCormley, you mentioned in an answer to one of your questions that there was something you were denied. Can you clarify that by the auditor? You were denied the opportunity to see something. Do you remember what that was? Because I didn't catch it.
Yes, we have asked for various pieces of information. The most important one is the information about the ballots and what he received from the United States Postal Service. We asked, we have been provided all copies, they're public record, of the ballot envelopes, but we have not been provided his counting. The judge instructed him to put 1 through 33 on each ballot and then scan the barcodes and find out the information. We do not know which numbers match up and the reasons why 4 of the ballot envelopes were not able to be read.
Did they give any response to you at all in terms of, in other words, did they explain why they weren't providing that information, or was there just no answer? How did that transpire?
The answer was the judge did not order us to tell you.
Okay. Thank you. A couple things I would mention here that haven't been discussed today when we're talking about linking the administrative code that implements the law with the law. I sit on the Rules Committee, And the Rules Committee is made up of Democrats and Republicans. It is a bipartisan committee. And the mission of the Rules Committee is to ensure that the legislative intent is followed when the administrative code is put into place. So when we're talking about separating the intelligent mail barcode from the tracing information, those sorts of things, the fact of the matter is that the Rules Committee is meticulous, Democrats and Republicans on this committee, at ensuring that the legislative intent is followed when the administrative rules are allowed to go into place. In fact, on the Rules Committee, I've been through 3 or 4 of them, and we have sent agencies back on several occasions telling them you are not following legislative intent, or you do not have the authority. You've gone further than what the legislative intent was. That process was followed in the implementation of the intelligent mail barcode. We've had a lot of talk today about, the fundamental right to vote and those issues, and that is why this is so difficult for all of us, Democrat or Republican, sitting on this committee. That is why we have a process to contest elections, and that is why the term rule of law has been mentioned so many times, because when you have a contested election in a situation like this, I think your only choice is to follow the rule of law to the best of your ability, follow the facts where they lead, and don't change the rules in the middle of the game, because ultimately that is not fair to anyone. And I'm sure if the shoe was on the other foot, we would understand that. So the question is, in determining the legislative intent and the definition of intelligent mail barcode, are we in fact, changing the rules or changing the intent of the code, or are we not? I believe the court hit it right on the head, and Representative Winchell, you mentioned it when they said we have to determine the definition of intelligent mail barcode. With that, I would say that there is no more committee work this week. We will adjourn at this time. We will be announcing at a later time what the next step is. Please get those lists for the witnesses that you'd like to bring forward, along with justification as to why. So we will adjourn at this time. In 10 minutes, Republicans will caucus in this room. Thank you, and have a great evening.